Okay, so thanks Adam and Mila, and thanks everyone for this really wonderful conference. I think this is a really crucial topic in constitutional law, and I'm really happy for all of us to gather here from virtually around the world to discuss this. I'm going to talk about today on conflicts of religious freedom and the right for equality, and specifically about a question that has been very, very relevant and preoccupying the courts in many states, and particularly in the United States, which is the question of religious exemptions from anti-discrimination rules. And let me begin by really presenting a little bit of the background for this project. So in recent years, the market of wedding services has really become the hotspot of religion equality conflicts, with a growing number of businesses, including reception venues and wedding photographers and videographers and calligraphers, and wedding cakes, so cake shops and florists and even wedding planners, more and more businesses implicated in discrimination lawsuits over denial of service to same-sex couples. And we currently have about 10 such cases percolating through the courts, and probably more coming. And the conversation on religion equality conflicts such as these really centers on the question of religious exemptions. So should equality rules exempt religious objectors or not? Should exemptions be granted? Will exemptions solve the conflict? And I want to acknowledge right at the outset that this is a really heavy normative question that is obviously multifaceted and involves many arguments at different levels. And this project certainly does not attempt to exhaust the normative debate. It really focuses on a single argument, which is very central in litigation and in the scholarly debates on religious exemptions. And I call this argument the consequentialist argument. And this is really the argument about the anticipated consequences of granting religious exemptions. And what I think is both fascinating and deeply troubling about this argument is that both sides of the debate harness the consequentialist argument for their benefit without actually providing data. So opponents of religious exemptions say, no, exemptions should not be granted, because if we grant exemptions, then faith claims would escalate in number and significance. So exemptions will not solve the problem, they will only exacerbate it. Whereas proponents of religious exemptions are saying, yes, exemptions should be granted, because religious objectors to same-sex marriage today in America and elsewhere in the democratic in Western democracies are a negligible minority, ever reducing in size, and there are ample market alternatives for same-sex couples. So nobody is going to be hurt if religious objectors are going to be exempted. But as I said, neither side actually has any evidence on what the impact of religious exemptions is going to be like. So in previous work, I studied the impact of varying legal outcomes in religion equality conflicts in the lab, and also did some qualitative studies on this. But in this study, what I do is I go to the field to examine this question in the context of the Masterpiece Cakeshop versus Colorado Civil Rights Commission case from 2018. So the Masterpiece Cakeshop case, for those of you who don't know it, is a 2018 Supreme Court case which pitted against each other a same-sex couple and a religious baker in Colorado. And the baker refused to create a custom wedding cake for the couple. The baker lost all the way up to the Supreme Court, and the court, after granting cert, ultimately decided for the baker. So when I was following this case, and particularly the oral arguments in Masterpiece, what I realized just from the way the judges were asking questions, and specifically the swing justice on sexual orientation and same-sex rights more generally than Justice Anthony Kennedy, the kind of questions that he was asking in some of the progressive justices on the court, as well as the conservative justices, it seemed like there is a fairly plausible chance that the court would rule for the baker. And that seemed like a good opportunity, setting the stage for examining the effect of religious exemptions in the field. So obviously I didn't know what the reasoning is going to be like, and ultimately the masterpiece decision came out quite narrow, but it was widely covered all across the nation and primarily in conservative outlets as a win for the baker. Okay, so masterpiece was actually decided against quite a complex legal background, which would really take into account when we think about what kind of outcomes it might have. So currently in the United States, we have states that are what I call in the paper AD states, anti-discrimination states. Colorado, for example, is an AD state. And these are states that explicitly prohibit discrimination on the basis of sexual orientation, and specifically in this field of law, namely public accommodations. And just like in brackets, I will say that the Bostock decision that came out this term actually does not impact this area of law, because that decision was dealt with employment law, whereas we're dealing here with public accommodations law, and these laws are different. And then as we have anti-discrimination states, we also have what I call RFRA states. RFRA is an acronym for Religious Freedom Restoration Act. So not going to give here the full history of this, but these are states that extend heightened protection for religious liberty. And I will say also in brackets, the definition is slightly more complex, or states that has heightened protection of religious liberty also in their constitutions. And I delve into this in more detail in the paper, but just to, as you can see here, the overlap between AD states and RFRA states exists, but it's actually quite narrow, at least at the state level. There's more overlap in local government level, and this quite complex legal setting really creates a 2x2 matrix, right? I mean, some states have anti-discrimination law and do not have RFRAs, and some states have the opposite, and some states do not have any of these. So to account for this variation, for the potentially different outcomes that a national SCOTUS decision might have on the wedding market, what I did is I searched for jurisdictions that were similar in all other important respects, including, I lost my, wait, okay, including GDP and the percentage of citizens who are religious, and percentage of Republicans and percentage of evangelicals, because many of these conflicts are driven, or at least seem to be involving evangelical litigants, and percentage opposing to LGBTQ rights and opposing to same-sex marriage. So the states that you see in the table here are similar in all these respects, except for their legal regimes. And I want to say two things here. So first, why do you see Texas and Indiana in two cells in this matrix? So ultimately, when I tried to look at the overlap states, there are only 4 overlap states that have both RFRA and an anti-discrimination law. They're too distinct in terms of all of those other variables to even be thought of being compared. But when you actually look at other forms of overlap, you see that there is lots of overlap within states, such that some local governments, for example, in Texas and Indiana, have national RFRA, so they have state RFRAs, so they have at the state level heightened protection for religious liberty, but within the state, there are some municipalities that extend protections for sexual orientation in the public accommodations market, and some that do not. So that created a more a more accurate in terms of demography comparison for, for, for trying to understand how a national shock might influence various legal settings. And the second thing I want to say, again, really at the outset, there was no attempt here to make any causal inference, to infer any causal relationship between legal regime and discrimination from this design. So obviously legal regime cannot be disassociated from social climate, from sociological and political conditions and so on. But I still think that it's really important to account for this variation. So you can think about it as sample stratification in a sense. So to investigate potential correlations with market outcomes. And this setting really sets the stage for the experiment that I'm going to describe to you now. So what I did is I sampled about 1,000 businesses from these 4 legal regimes. And these businesses, on the beginning of May 2018, received an email inquiring about the wedding services from a same-sex couple. I should say that businesses included both florists, photographers, and cake shops. And then a week later, businesses received an email from heterosexual couples. And then I waited. And then on June 4th comes up the masterpiece decision, and it turns out that the court actually rules for Jack Phillips, the baker. And then at this stage enters a control group. So these are businesses that I did not contact before. And the purpose of this control group was mainly to allow me a comparison of the internal validity of the design of the experiment. And then 1 week after masterpiece, each of the businesses that previously received an inquiry from a couple receives either an inquiry from a heterosexual couple, opposite sex couple, or a same-sex couple. And then 1 week later, they receive the counterpart email. So what I want to acknowledge here first about this design is first that it provides us a very rich evidence, because we get both within business evidence. So we have 4 observations of every business in the sample. We get both before and after masterpiece, and the time period is condensed, so we can actually determine the causal effect of masterpiece on these businesses. And we also get between subject comparison because of the randomization that followed up the decision. And I also want to acknowledge the weakness of the design, because prior to masterpiece, there was no randomization. And I can talk a lot about this in the discussion, and I can also refer to the paper, but there's lots of things in the empirical strategy of the results that balance that attempt to account for this feature of the design. So I want to focus now on the results. So what we're going to see here is the agreement to serve same-sex and opposite-sex couples after masterpiece. And as is common in field experiments, I had some attrition between waves. So the level of cooperation fluctuated between waves of the experiment. So ultimately, there were lots of empirical strategies to try and see whether the results are robust. And what you're going to see now is just like the one figure that really summarizes the vast majority of the empirical work. And what we're going to see is the percentage of businesses agreeing to provide service after masterpiece. We're going to see this on 4 cohorts. One is all businesses in the sample. The second is just the control businesses, so only businesses that were contacted for the first time after the decision. And then we're going to see the same results for those businesses that prior to masterpiece were gay friendly. So they agreed to provide service to same-sex couples. And we're going to see that analysis also for the group of businesses that prior to masterpiece were really generally very keen to provide service to everyone. What we can see is really that although the baseline of agreement to serve same-sex couples differ between those groups, the results are identical for all cohorts. So we see a decline in the willingness to provide service to same-sex couples after Masterpiece. And I want to emphasize, even when you're looking at the group of businesses that prior to Masterpiece agreed to provide service to same-sex couples. So these are businesses that before Masterpiece responded positively to same-sex couples. After Masterpiece, we see a decline in their willingness to provide service. And there's lots of things I could say about the data, and I want to save some for the discussion, but I want to give you this final empirical slide. What you're going to see here is the impact of Masterpiece on those willing businesses that prior to Masterpiece were willing to provide service to same-sex couples. You're going to see now the effect broken by, or as a continuum of the religious environment. So on the x-axis, what you see is the density of religious congregations at the county level. So here, really right next to the beginning of the axis, these are areas where essentially there are no religious congregations surrounding the business, whereas here at the other end, these are really dense religious areas. And what you see here really quite strikingly, and this is also highly statistically significant, is that the businesses essentially updating their behavior, or businesses that were in highly religious environments. And I could talk a little bit about the mechanisms for that. And essentially, and I talk a lot in the paper about cognitive mechanisms and social mechanisms, but really these are the businesses updating their behavior. And interestingly, there's no change really in the level of cooperation with opposite sex couples for this cohort of businesses. All of the difference comes from same-sex couples. Okay, so I want to talk now about
Please be mindful of time though, right? Because we only have half an hour in total. Just want to mention that.
Yeah, so this is my last slide. So okay. I want to talk about the implications for the legal debate on religious exemptions. And so there are two things that are important here. First is the impact of Masterpiece on discrimination. So I think, if we're just going back to the consequentialist argument, the very simple counter argument, what do exemptions do? We see that exemptions expand discrimination. And crucially, I think the experiment does show that market alternatives exist. So you see that in every area there are businesses willing to serve same-sex couples. It's not like those businesses vanish, but the risk of experiencing discrimination is really quite substantial. So going back to my first slide, think about the fact that there is on average a 9% average risk to experience discrimination from the businesses. And then there are about 10 categories, sometimes more, sometimes less, but this is pretty standard for a wedding to have all these need all these services, to have contact with all these vendors. And then typically a couple inquires at least one vendor in this list, but mostly at least two vendors, sometimes even three. So what you really get, and we can get into the probabilistic calculation afterwards, but this is between 61% to 85% total risk of experiencing discrimination in the organization of the wedding. So this is quite a substantial risk. And what does it really tell us about the theory of religious objection we started with? So we had two theories, right? One is that demand for objection is fixed. And if that's the case, exemptions should not increase demand. The other was that demand for objection is flexible. So exemptions should increase demand. And this is a theory that's borne out by the data. And I think that really creates a really hard dilemma for a court, because I personally think that there are certainly cases where we would want to provide exemptions for religious objectors. And really the question for court is it possible to provide justified exemptions without increasing the demand for these objections and increasing unwanted, undesirable phenomena such as discrimination? So there's lots of things more to say, but for now, let us open this to questions.
Okay, so let me just quickly say there is already 4 comments, I think, on the queue or questions, people who've expressed interest in asking questions. So let's not let's not answer questions, Netta. Sorry, but we only have 10 minutes, so I think you may get just the questions in. So I guess Kevin is first. Sorry, Adam, you're moderating. I'm taking over your. You don't care. Okay, Kevin.
Hi, Netta. Well, first of all, this is one of those papers that when you read it, you're just kind of kicking yourself that I didn't have the foresight to do this paper, though I doubt I could have executed it as well. So I'm really glad you did, and it's really interesting. So just two quick things. First of all, if I understand correctly, your outcome is binary, such that they agree to provide the services or don't agree. Is that right?
I also have a more granular, nuanced outcome. They come out the same.
Okay. Well, I wasn't sure if you consider attrition to be when they don't respond at all. Is that right?
Right. So yeah,
Okay.
I'm not supposed to answer, but Max, I'll say that in the chat. I'll answer in the chat.
Okay. So it is. So I know that, and Charles maybe could speak to this better, but I know a number of other audit studies that people have done have simply considered if there is no response essentially to be a rejection, because that would be one way of a person or a business who sort of has an anti-gay bias, but don't necessarily want to out themselves and don't want to be on the record as denying service, to just sort of not respond. With the idea, that they would have responded to a straight couple. So I just didn't know if you had disaggregated the outcome in that way, and if there might be some more interesting effects there. Two, so there are different theories about why people would discriminate, or what it is about same-sex couples that causes this discrimination. In the actual Masterpiece Cake case, there was a lot of discussion in the lower courts and then in the Supreme Court, though it didn't actually come out this way, as you know, about expressive activity, right? Some people thought this could come out on First Amendment grounds, and it kind of turned on this question, which was unresolved in the record, which was, did they were required to say, congratulations, I'm sorry, I forget their first names, Joe and John or whoever, and thus sort of with their expression to condone same-sex marriage. So, pretty much everyone agrees, I think, that this rule, if it were extended to, say, officiants, we wouldn't want to require, say, officiant to celebrate same-sex marriage or same-sex love. On the other end of the spectrum, where there's no expression, say, renting a tuxedo or renting a limousine, we would. So I was wondering if with your different vendors, going from flowers to cakes to, and I forget the other thing you used, that I think was less expressive, if we see a difference between those, with the idea being that people feel comfortable discriminating when they're being forced to express themselves and support gay marriage, but less so when it's simply just a transaction like a tuxedo or something like that. And you said they were all robust, or they were all significant, but I wonder if you saw any differences between the types of vendors. Given the name of the case, people might think it's just about cake, or I don't know. So something to just wondering.
You do not get to respond, Netta. And also, let's do a one question rule. In Kevin's case, it can come out of his own presentation, I guess, but let's try to do a one question rule for this. Let me see. Actually, Alex, did you want to ask a question? Because you put them in the chat. No? Okay. So then I'll move on to Matthias.
Thanks for the paper, which I read with great interest and enthusiasm. I very much liked the experimental approach. My one question, and I have to keep it simple, is to what extent the change in the behavior can be really attributed to the judicial decision as such, as compared to the public media debate surrounding it. I know from the ECTHR Ladale case, where the exemption claim was dismissed in the UK context, that these cases provide opportunities for conservative Christian litigants to prime and to highlight the salience of these issues, and that may be the driving factor causing the change in behavior. So be interested in how this can be disentangled.
Mm-hmm. Great. Let me see, who do we have next? Maddie? You don't need, okay, so then I move to Charles.
Right. So really, really cool work. I'm going to keep this really, really short. Love audit studies. People should do more of them. I would, more of a comment than a question, especially because of time, but I would lean more heavily on the experimental results that you actually have after the masterpiece decision, and then try to actually frame everything else as just a diff and diff, right? So you pool the data, you have an indicator for whether or not you have a request for same-sex marriage, you have a period indicator. It doesn't allow you to get at the causal effect of the decision itself, because there's a month window, right, that passes during that period. So there are all these other things that are going on, but I think that'd be a more straightforward way of showing people that these differences across the time period are actually real, because it's kind of hard to chart that by the bar chart. Like, we're going to have measures of uncertainty, right, around the difference between the periods. So we don't really know. And then, so just do, you know, an OLS and cluster standard errors at the treatment level, so at the individual respondent with the interaction term. And I think that's the quantity of interest that you probably want to lean the most on in the paper. So.
Right. Who is next? I think a number of people put their questions in the box. Neda, if I may, so I've commented on this paper before, I've seen this paper before. I think it's a great paper. I do think, for me, it raises a question. One of the questions it raises is similar to what Alex put in the chat box, I guess, right? You're finding that you mainly find this negative effect, or the impact in religious environment. And the question is it the religious environment as a whole, or is it people that have religious beliefs that are changing their behavior? And if it's people that are religious beliefs, then I think it raises the question, right? Which I think is a question that also very much spills over to the next paper. Is it only people that hold certain views that are change their behavior or opinions in response to constitutional law or constitutional cases? My intuition, my prior is, I think that people's priors matter in whether or not they respond to constitutional law. And I think it's probably impossible to disentangle that. And I'll end there, otherwise I'm myself asking the never-ending law professor question. And Adam?
This is related to where Mila ended, which is, I both thought the way that you blocked out the sample and even the slide, the way that you showed it visually, but also in the paper is just is great and really careful and really clear that you thought about how to make sure that you were getting sampling from places that were similar in these various ways: religion, political parties, GDP, et cetera. The question I had from that is then how generalizable we think the effect might be, and if it might be really just concentrated in these counties. And that's also relevant to the back of the envelope calculations that you do to say, what's the likelihood that people might experience this discrimination? And so I just wonder how, I think it's very convincing. It's such a cool project. Extremely convincing evidence that these effects materialized in these kinds of places. But I don't know how to think about whether or not it would materialize across the country or how frequently.
Okay, so now I'm going to do this very unfair thing and give you like 2 minutes to respond to everybody. So you pick. We'll keep.
Right. So I'll do two things. So first, I'm going to say that I want to respond in the chat. Hopefully that's allowed to all of the major questions. And I just now maybe to just show, I also grapple with a question that Adam was asking now. I just want to show you this one last figure from the paper, which is to really break down the results by regimes. And one of the things I found that I personally find most interesting, and I want to follow up on in future work, is the effect of legal regime, to the extent that the legal regime in effect. And what you can see here is that really we see the effect in all legal regimes, even in regimes that we would not expect to see the effect, except for regimes that have both an anti-discrimination rule and a religious freedom protection rule. And these are within state variations. So really controlling for everything else, except for potentially the political environment that led to the inaction of these different legal regimes. And I think that really presents really fascinating questions that could, and if we could find answers, they could be really helpful for finding solutions for these conflicts. Because going back to the major frame of where we are in these in this conference, we have here a conflict between two fundamental rights. And if part of the solution is in nuancing our legal regime such that they acknowledge sufficiently both rights, and I think that this is a really hopeful ending. So I'm going to answer all of the specific questions in the chat, and thank you very much.
Wonderful. Let's actually, in this case, let's clap for a great paper. No need to do that for a book that's already out in print, but I think that's great. Okay, so I guess Charles and Kevin have the next half hour to present and to get comments.
Okay, thanks a lot, Mila. Thanks, Adam. So this is actually, I think, a good segue because she didn't get to talk with them in much depth, but Netta has these two theories about how constitutional law might impact policy or have an effect on society. And one of them is about being given legal permission to do something, and the other one is more about an expressive view, which is related to what we're trying to get at with this paper, which is how constitutional law might affect public opinion of different policies. We know from a vast amount of literature, some of you all here have contributed to, that the public opinion is critical in most jurisdictions for enforcing constitutional law. This is true even in those that have robust independent courts and have mechanisms for that. Public opinion matters. We're seeing that with the Supreme Court justice confirmation now and that whole debate and so forth. So I think it's worth trying to figure out to what extent and what context constitutional law might have normative force, whether it would have an independent coercive pull. Of course, a lot has been written by legal theorists, but there's been very little empirical work on it. Of course, there has been a good deal of empirical work into the similar phenomenon in international law. People, Katarina here has worked on that. Adam and Mila, of course, in this book and other places. And just to summarize it, because we build on it here, there are different approaches, but they all involve telling respondents about some policy or some proposed course of action by the government, and then randomly telling a subset of those respondents that it violates international law, or perhaps even that it's consistent with international law. And then we want to observe whether that diminishes people's support for the policy or increases it. And one fairly consistent finding here is that with international law is it does appear to have some positive normative force. When you tell people that international law, that doing something would violate international law, people tend to like it less, all right? But there's been very little of the equivalent research into constitutional law. Adam and Mila have talked about some that they did, but other than that, there just really isn't much out there. But what Mila and Adam find, and a couple other studies, is that when they do the same for constitutional law, they either find no effects, null effect, or sometimes even a backfire effect. For example, their Wikipedia ban in Turkey and Erdogan supporters backfiring or backlashing to a treatment about constitutional law. So this appears to be a growing mystery, right? We have international law having a positive normative force and constitutional law either having no effect or a negative one. And so we want to try to dig into this and try to figure out this mystery. One kind of what we call the naive explanation that's maybe obvious is that maybe constitutional law just is has less normative force as a value than international law. So people either attach no value to it, or in the case of a backfire, they attach negative value to constitutional law qua law. And that, of course, especially in the United States, but also in other countries, is implausible, right? We think of constitutional law as a civic religion. People revere it, even if they don't always respect it in practice or apply to certain things. If you tell people that something is constitutional or unconstitutional, generally people in the abstract want to uphold the Constitution. So a limit of these international law studies and in the constitutional law studies is that they've been done at different times on different norms and different laws. So because they're testing different things, we can't really say whether the difference was, the reason for the different effects was simply constitutional law or international law. It could be that they were testing different types of norms, right? We haven't controlled, in a sense, for everything else. So this project is about trying to test those two at the same time on the same type of norm to see if we can untangle the effect here. So we first develop a couple different theories about what could be going on if we do see a negligible or backfire effect for constitutional law. The first one is that what we call a phenomenon called being treatment proof, which is a little bit related to what some political scientists have called pre-treatment, but it's a bit different. So obviously when we run these experiments, we can tell someone that something is unconstitutional or constitutional or violates international law or not, but we can't control their belief, right? They may not believe it. And what we're interested in is not how they respond to a message, but what happens when they believe something is true. So if they're not actually persuaded when we tell them this, then we can think of them as not actually being successfully treated, right? Because they're not believing it, and thus they're not carrying that normative belief into their evaluation of a policy. And we think that this failure to treat or treatment proof or even control proof will happen most often when people have significant real life exposure to the treatment. In other words, we can think of this as being pre-treated, right? They've already have an entrenched set of values, and no experimental manipulation is going to change that. And we think this is much more likely to happen with constitutional law, and especially with the types of topics that we're interested in constitutional law, which, like Netta's paper, are often in the news and people have well-formed views about. But the second is that kind of explains why there might be no effect, but why would there be a backfire effect? So we build on some of the literature by Brandon Nyhan and others about that suggests that when people hear unwelcome information that contradicts their sincerely held views, they spend time reasoning against it, right? And they kind of build up, they kind of dig in and entrench themselves, and it actually creates a backfire effect where they're more likely to believe this false belief or this pre-existing, this prior belief than they were before. And Nyhan and others observed this with weapons of mass destruction in Iraq and in some other contexts. So as kind of a last minute thing this week, I added a formal model that tries to formalize this phenomenon and lets us tease out some of the components here. We don't have time to talk about it now, but I have a little slide at the end if anyone's interested. It's in the paper. But this allows us to, this model and these theories allow us to test this with an empirical survey. We did that. We're following up with a second survey this week where we kind of correct some of the things and tweak some of the things. We're asking about child separation, family separation again, but try to get at some of the mechanisms and the theories we've developed in the meantime. So to tell us about how we tested this empirically, I think we have about 4 minutes-ish left. Charles is going to tell us about the research design and our results.
We got about 2, but that's okay. So research design, we did a survey experiment. We did this with a nationally representative quota-based sample of 3,007 Americans. We had quotas on age, gender, education, income, etc. So broadly representative of the national population. We randomized if the policy, the family separation policy, was framed as either violating international law, constitutional law, and whether the refugee actions were legal. For time constraints and for the purview of this paper, we're only focusing on the effects of our international law and constitutional law treatments. We have a long description that we tried to make as objective and as kind of partisan neutral as possible about the family separation policy that every respondent actually read. You see it's very, very long. And at the end of it, we interjected our treatments. Now, the fact that it's really, really long and our treatments are really short and buried at the end of it, and what we know about respondent kind of attention in online surveys should suggest to you that any effects we find are a lower bound of possible effects. We stacked the deck actually against us finding anything at all. So there are 9 total treatments across the 3 factors that I described. The 2 that we're going to be focusing on today are the international law one, which says as to the legality of the government's family separation policy. Many legal experts believe the policy violates 1 or more international laws, etc. And then the constitutional law treatment, which begins in the same way, but it says many legal experts believe the policy violates the constitutional right to due process of law. Our outcome measure is whether or not people actually support the government's policy, and this is on a strongly support to strongly disapprove. I forget the exact language we use, but it's a 1 to 5 ordered Likert scale. And I'm going to show you the results from a series of regression models. Oh, that's my time being end, but I'll quickly go through these. So the regression models include treatment indicators for the constitutional law and international law treatments, and a bunch of pre-treatment covariates to increase precision. Here are the estimates: 95% CI and 90% CI bars for the constitutional law and international law treatments. You see, obviously, that the effects go in opposite directions, right? International law treatment seems to have a weak effect on actually decreasing public support for the law, although this is estimated imprecisely. And the constitutional law has this big kind of positive effect, this backfire effect of about 1/10 of a standard deviation on increasing support for the policy. This is kind of a Goldilocks zone where the effect isn't too big that we might actually think it's some sort of statistical artifact, but it's also not too small that we can easily dismiss it. And in line with some of the theory that we have in the front end animating why people might experience a backlash effect, we look at treatment effect heterogeneity to see if people that might really not like to receive information about the illegality of the policy might reply to it. So we look at how Trump voters actually respond, and we look at how Fox News viewers respond, and we find that the backfire effect basically is limited to those groups. And that difference compared to the other reference groups, non-Fox viewers and non-Trump voters, is statistically significant. So there's an interesting interaction going on here in treatment effect heterogeneity. And with that, we thank you, and we look forward to your comments and questions.
Okay, great. So I don't see any questions on the queue yet, so I'll give you all a second to gather your thoughts. Okay, I have Stefan, and I guess then I have myself, but Stefan, yeah, why don't you go ahead?
Yeah, thanks. Very, extremely interesting, extremely interesting. I'm just wondering, and this basically also ties into one of the chapters in the Adam Mila book, because they have something similar on Turkey, which you mentioned. Now, both Turkey and the US, sorry to say, have populist governments. So I'm wondering if you have thought of replicating such a study, say, in Switzerland or Belgium or Denmark, because, you know, obviously, as you just showed, results are primarily driven by either Fox News viewers or Trump voters. And the same seems to be, if I remember correctly, the case with regard to the Turkey chapter in the book, where it's made primarily Erdogan voters, right?
Mm-hmm. It's great. Let's try
Are we
to.
answering now, or are we collecting?
We're collecting questions if there are more questions. I guess.
Mark had a question, didn't he?
Who had a question? Sorry, did I miss it?
Mark?
Mark Raver?
To elaborate just a little bit on the chat question, I'm wondering whether there might be variance on how the public or Fox viewers or Trump viewers groups consider the expert group. So consider us. If someone said to me, most experts on constitutional law think X, my first reaction might be, well, most experts on constitutional law are progressives. Whereas if somebody said to me, most experts on vaccines think X, my thought would be, well, they're really experts. So to the extent I disagree with the experts on con law, I'm just willing, you know, if anything, to say, those what the liberals think. And I'm wondering, I think people have been primed to think experts on con law are just partisans. Have people been primed as much to think experts on international law are partisans, or would, for more people, experts on international law bring to mind experts on vaccines before Trump than experts on constitutional law.
We have another, we'll take a few questions and then you get to respond. I have Barry and then Adam. Barry, you had a question?
I think my was actually somewhat similar to what Mark was just mentioning. I mean, I guess I wonder if the people in the Fox and Trump groups in the subject pool might have believed that the constitutional law experts are progressives, liberals, Democratic Party members. That could perhaps help explain the results. But for that matter, they might think the same thing about the international law experts. Although on the other hand, there's John Bolton. Everybody in that group is probably aware John Bolton's an international lawyer and definitely not progressive. So I wonder who they were thinking about when they were thinking about the international lawyers. And I'm not so sure if globally international lawyers are as progressive as American common law scholars. Quite a heterogeneous group.
And Katerina says you had a related point, so I'm going to go to Katerina first, Anna.
Thank you. So I just wanted to summarize some of what Kevin said in some of these responses. So as Kevin said, our prior as lawyers is constitutional law is higher status than international law. So we should have stronger effects when we have international law and stronger effects when we have constitutional law treatments, weaker effects for international law. And that's not what the literature in this paper say. So that's a nice puzzle. One way to connect what Barry and Mark were just saying is that the status of foreign experts or international law or the UN gets heightened because they're perceived as neutral, whereas the Americans are perceived as partisans. I had some similar findings in my own book when I had like a UN recommendation and American experts recommended. I couldn't make any sense of why the UN recommendation would generate bigger effects, but that's the explanation I went with, that this is, a disinterested group. And the way I tested that then was to look for differential effects. So I thought I was looking at labor issues. So I thought among Democrats, it would be the effects would be of American experts would not be perceived as partisan, but among Republicans, if this were true, so there might be some similar possibility to test for this example of like perceived neutrality of international law over constitutional law by looking at differential effects by partisanship. And then I also really liked this idea of pretreatment and broadening the understanding of pretreatment. Like the reason why constitutional law might not resonate with us is because we've heard about it, as Zach mentioned, kind of since day one. Like we all know what Roe v. Wade means if someone, and I think Zach Citrin did in fact do this experiment. He said, oh, Roe v. Wade in like 1990 or 2000 just said this and opinions on abortion didn't shift. I think there is some sense that like you can't shift opinions when people already deeply know and have fundamental beliefs about what is and is not constitutional. So I just wanted to just say I completely agree with what people have been saying.
Adam?
Yeah, so first off, I'm annoyed that you guys wrote this paper in the sense that, I have papers that are on both sides of the nothing for constitutional and yes for public international law. And I always thought sooner or later, when we're done with this book or other things, need to research why this difference exists. And you guys obviously have thought of a great way to do it and find the finding that the things go in the opposite directions as with prior things and get at it. So it's great. And I'm really glad you guys did this. Well, once again, not glad you did, glad this is playing out. Now, I was trying to think, I like both of the mechanisms that you guys posit make sense and they're plausible to me. But a few other thoughts on possible mechanisms. So one is that the naive, as you guys put it, the naive explanation makes perfect sense in the US setting that no one's gonna really find that persuasive. But I always thought it might be possible that in other settings that people would find the naive explanation persuasive, in Turkey or in Kazakhstan, where one of these experiments was, and some of these other places where I thought it might be possible that people thought that their constitution was crappy and imposed on them by some dictator or something, but that the international treaties were good things that were, thought of by reasoned Europeans or something like that. And so that they were pro the treaties and against their constitutions. And so I wonder if the naive explanation, is still plausible, just not in the US setting where, like you guys said, it doesn't even, you can just almost disregard it out of hand. It doesn't make sense. So that's one, is the naive explanation may be better other places. The second thing is, I'd always wondered whether or not people thought that there were consequences to international law violations in a way that doesn't exist for constitutional violations. I think people know that their governments sometimes ignore rights, sometimes they respect rights, but they know that the fact that it's unconstitutional, at worst there's electoral consequences, but not practical consequences. But that people might think that there might be consequences if they violate their international commitments, that they'll lose trade access or aid, or maybe in some of these other countries like Kenya and Turkey and Kazakhstan, that maybe they'd be invaded even or something, I don't know. And so whether or not that might be a mechanism to try to look for. Again, in the US context, it doesn't seem as plausible that people would be afraid of, UN blue helmets rolling in for the border policy, but maybe in other places. And then finally, the third point is, within the sort of pre-knowledge thing, you can imagine two different kinds of pre-treatment. One is pre-treatment about constitutional argument generally, and another is pre-treatment knowledge that's based on like this specific topic. And it's possible, for instance, that people have heard constitutional style arguments about border policy in the US, or that they just have heard constitutional arguments since high school or since civics classes and things, and that those might be slightly different forms of pre-knowledge to differentiate between.
Mm-hmm. Yeah, great. If I may, I think there's time for me to also ask a question. So to me, it seems like the most counterintuitive, puzzling, and interesting part of the paper is this backfire effect, right? Potentially there's big policy implications there. You tell people, I mean, for Adam and me, we find this interesting, I guess, or you tell people, hey, this is unconstitutional, and people are like, okay, now we're supported more. That just, I mean, and I think the mechanism you're identifying, I know you build on prior psychological studies, and there is some prior evidence that suggests that, but it does seem to me that this only occurs under a very limited set of circumstances, right? People must have first already heard something else that they believe, namely that it's not constitutional, that Trump was merely doing its constitutional duty by, as opposed to violating the Constitution, right? As you said, Breitbart and Fox News were saying, and that they believe very strongly, I guess, and that you must have some highly polarized context. So in other words, like, I guess my question is, when else would you expect such a backfire effect to occur? And I mean, actually thinking about Adam and my Erdo Wikipedia ban survey, we kind of said, well, maybe people took it as a cue that Erdogan found this really important, so that's why we find a backfire effect. But maybe this is actually the same. It could be that what you're theorizing explains our findings as well. But I just wonder, to what extent does it generalize to any other settings? And in that sense, if you're running this survey again now, right, would you expect to find the same thing, or would you expect to find something else? Because actually the family separation policy is kind of back in the news, but not to the same extent as it was before. So I think those are some questions. Okay, with that, you have 5 minutes, I guess, to answer all these various questions.
Great. I have some thoughts, but Charles, do you want to take a stab at any of them first?
Sure. So on the issue of generalizability, there's this interesting paper about the unconstitutionality of protections aimed at limiting the spread of COVID that a few people on this call have written, right? And in that we find that, reminding people that policies are against the Constitution introduces backlash effects in China and Taiwan. So there seems to be some evidence that this is beyond our specific context. On the issue that many people have brought up about experts, it's a really, really great point. And the situation, I think, is actually far worse than what we've discussed about here, right? So many of the survey experiments that actually have informational treatments like this refer to anonymous experts. We have virtually no idea how these experts are actually perceived across subpopulations, right? Which makes it really, really hard to actually determine what treatment effect heterogeneity means, because it could just be that these people are fundamentally viewing treatment effects in a very different light. They receive a different intensity, or the treatment is very, very different to them perceptually. Thankfully, this is kind of an empirical issue that we could sort out. In theory, we could have a bunch of MTurkers go out and like evaluate what they think are experts to speak about constitutional law or about international law. And we could see if those distributions across various different dimensions are actually different. My read as someone who is not a lawyer and is outside of the legal community largely is I didn't know that there were going to be differences between constitutional law and international law experts and perceived partisanship until I heard all of you actually talk about this. So I don't know if that's like a commonly viewed kind of thing, but that's something that we could actually go and do a post-test on. And I think more generally, there's really a desperate need to assess construct validity of these informational treatments a lot more than previous work has done. And I thank everyone for pushing us on this.
Could I jump? Oh, you're done.
Yeah.
Yeah, all of that, of course. You know, it's always a difficult choice how you phrase this. Do you want to simply announce to the respondent, you know, this is constitutional or this is unconstitutional, have this sort of disembodied authority telling them, you know, how do people respond to that, versus telling them, giving them some sort of more objective, you know, there's an expert consensus of something. Neither of those approaches is perfect. They each create the sort of problems we're talking about. But we settled on experts because we think that it probably has the least problems, though it still has issues, as several of you have mentioned and Charles just explained. One thing we can do, which doesn't directly get at this issue, but which we will do in the survey we're launching this week, is ask people, try to figure out at the end of the survey whether they were successfully treated. All right, so we can tell, we can figure out, did people at the end of the survey, do they now actually believe that the policy is constitutional or unconstitutional? And is there a relationship between the actual treatment we gave them and what they now believe, right? So that would give us some insight into how much weight or how much credibility they give to these so-called experts, albeit indirectly. Adam, makes sense. Yeah, Charles touched on that. Yeah, I suspect that as the consequences of international law, especially for this issue, that most people or very few people would think that there are consequences to how we treat, you know, unlawful migrants or asylum seekers, but maybe. And certainly you're right that it could be in some of these other studies where they're likely to be more, you know, sanctions of the sort that you mentioned. And finally, Mila, when do we expect to see it? Well, we expect to see it less now that when we redo this, now that the issue is less on people's minds, although there's still, I saw on 538 yesterday, they're still surveying people, you know, since family separation came up in last night's debate, right? So it's still on people's mind, and it may be refreshing people's recollection and bringing up those beliefs that they held, you know, deeply back 2 years ago that are now being reminded of it. And so we may not see as much of a change as we initially thought when we decided to do this a month or so ago, because people may be digging into it again, reading articles and so forth. But we do want to get it, like, we can have some measure of the amount to which people have received this real life treatment. And we expect, you know, per the formal model, that will have a big impact on the extent to how much we see a backfire effect or a null effect. I think we got everyone.
Yeah, I should mention as a moderator, I probably missed Sandy's question because you put one in the box, but we can respond to that. I guess
via chat.
Yeah, you can respond via chat. I think we're actually, this is perfect timing, right? We're on schedule, and we're now supposed to have a break for, is that right? A lunch break actually.